A unanimous Supreme Court decision just dropped, and it's sending shockwaves through every state capital in America. If you own a gun, carry a gun, or are even thinking about buying one, what I'm about to explain could completely reshape how you understand your Second Amendment rights. This isn't about one state, it's about all 50. Before we go any further, do me one quick favor. Hit that subscribe button right now. Why? Because 90% of gun owners miss critical legal updates like this, and I don't want you to be one of them. This ruling just came down, and most gun owners don't even realize it happened. Don't stay in the dark when your rights are on the line. Click subscribe now. Let's break down what just happened. The Supreme Court issued a 9-0 decision. That means every single justice agreed. Liberal justices agreed. Liberal justices. Conservative justices. All of them. When was the last time you saw that? Almost never. And when the court is unanimous, you pay attention, because that means something major just changed. Here's what the case involved. A gun owner challenged a state law that limited where he could carry his firearm. The state claimed certain locations were off limits, even with a valid permit. The gun owner argued that this violated his Second Amendment rights. Sounds straightforward. But here's where it gets bigger than one case. The Supreme Court didn't just decide that dispute. They established a framework that every single state must now follow when writing and enforcing gun laws. Let me simplify it. The court said that any gun law in America must pass a specific standard called the text and history test. It may sound complicated, but it's not. Here's what it means. When a state passes a gun restriction, it must prove two things. First, the law must align with the actual text of the Second Amendment. Second, and this is the big one, the state must show there is a historical tradition supporting that type of restriction going back to the time the Constitution was adopted. And this is where everything changes. For years, many states passed gun laws using a public safety argument. They would say, this restriction makes people safer, or this is a reasonable regulation. The Supreme Court just said that's no longer enough. Now, states must prove that people around 1791, the year the Second Amendment was ratified, would have accepted that kind of restriction. If they can't show historical support, the law doesn't pass constitutional review. Think about what that means. Let's say your state has a law banning firearms in public parks. Under older legal standards, the state could argue that the law protects families and children. That was often enough. Under this new standard, that argument alone won't work. The state must show that in the 1700s or early 1800s, there was a historical tradition of banning firearms in similar public gathering places, and that's difficult, because historically, people commonly carried firearms in many public settings. Do you see how this shifts the entire legal landscape? Laws that seemed secure yesterday could now be constitutionally vulnerable. And this isn't theoretical, it's already happening. Several states are actively reviewing their gun statutes. Some laws are being challenged in court this week. Others are being quietly reconsidered by lawmakers who understand they may not survive under this new framework. If this breakdown is helping you understand what's going on, imagine what you'll gain from the next video where I explain the 5 specific words attorneys recommend when police ask about your firearm during a traffic stop. Subscribe so you don't miss it. Those phrases can matter more than you think. Now let's talk about the states most affected. If you live in California, New York, New Jersey, Maryland, Massachusetts, Hawaii, or Illinois, pay close attention. These states have some of the strictest gun regulations in the country. Many of those laws were built on public safety justifications rather than historical tradition. Under the Supreme Court's new framework, that creates vulnerability. Take New York as an example. There is a requirement that applicants demonstrate a good moral character to obtain a carry permit. On its face, that sounds reasonable. But under the new test, attorneys are asking a different question. Where is the historical tradition for that requirement? Was there a standard in 1791 requiring citizens to prove a good moral character before exercising their Second Amendment rights? If not, the law could face serious constitutional challenges. Now let's look at California. California restricts carrying firearms in what it defines as sensitive places. Again, that may sound reasonable at first glance. But under this new Supreme Court framework, the question isn't whether something sounds reasonable. The question is whether there's a historical tradition supporting that restriction. Back in the late 1700s and early 1800s, there were some limits in specific locations like courthouses or certain government buildings. But what about shopping malls, movie theaters, large entertainment venues? Those didn't exist in 1791. So how do states apply an 18th century historical standard to 21st century locations? That's the exact issue courts are wrestling with right now. And there isn't a clear answer yet. And here's something most people aren't talking about. This ruling doesn't just affect new laws. It affects old laws too. Restrictions that have been on the books for decades are now being challenged under this new standard. A law passed in 1985 that everyone assumed was constitutional could now be struck down if it lacks historical support. Think about that for a second. Rules you've followed for years because they were a settled law might not remain in place. But there's more. This decision also changes how lower courts must evaluate gun laws going forward. Before this ruling, courts used different standards. Some applied stricter scrutiny. Others were more deferential to lawmakers. There was inconsistency across jurisdictions. Now, every court in America must apply the same text and history test. That creates uniformity. But it also means that many past court decisions could lose their relevance. Cases decided under older standards may no longer hold up. Precedents that shaped gun law last year could be overturned this year. Let me give you a hypothetical example. Imagine your state prohibits carrying firearms within 1,000 feet of a school. You've complied with that rule because it's the law. Under previous standards, courts often upheld those restrictions based on public safety, especially protecting children. Under this new standard, the analysis changes. A court would now ask, did similar buffer zones exist in 1791? Was there a historical tradition of establishing fixed distance-based firearm restrictions around schools at the time of the founding? Of course, schools in that era were small, often one-room buildings. Firearms were common. Structured 1,000-foot zones didn't exist in the modern sense. So does that law survive under the new test? That's exactly the type of question courts will now have to answer. Quick legal note. This is educational information, not legal advice. Every state has unique laws and legal interpretations. If you have questions about your specific situation, consult a qualified attorney who specializes in firearm law. Now let's talk about what this means practically for you. First, if you hold a concealed carry permit, understand that the list of places where you can and cannot carry may shift over time. Some restrictions may be challenged and removed. Others may be restructured to attempt to fit within the historical framework. The legal landscape is changing. Staying informed matters. Second, if you were denied a permit in the past, this may be the time to revisit that decision. Standards have shifted. A reason that justified denial under older legal tests may not withstand scrutiny under the new one. That doesn't guarantee success. But it could open doors that were previously closed. Speak with an attorney who understands Second Amendment litigation. They can evaluate whether your case is worth pursuing under this new framework. Third, keep an eye on your state legislature. Some states will attempt to rewrite their laws to align with the historical test. Lawmakers will look for examples from early American history to justify modern restrictions. Other states may decide not to fight uphill battles in court and instead loosen regulations proactively. Either way, change is coming. And you need to know what's happening where you live. Here's something else that should get your attention. This 9-0 decision brought together justices who rarely agree on anything. When you see unanimity at that level, it signals that the constitutional issue was clear to the entire court. When judges across the ideological spectrum reach the same conclusion, it tells you this wasn't a narrow or technical shift. It was foundational. And what the court made clear is this: the Second Amendment has a defined meaning. States can't sidestep that meaning simply because they believe a particular restriction is good policy. Policy arguments alone are no longer enough. Now let's talk about what happens next. Legal challenges are going to surge. We're talking about potentially hundreds of cases across multiple states. Some of those challenges will succeed. We'll learn which types of restrictions can survive and which cannot. But here's something you absolutely cannot do. You cannot ignore existing laws just because you believe they might be unconstitutional under this new standard. Until a court formally strikes down a law, it remains enforceable. If you violate it, you can still be arrested and charged. That's the reality. Even if a law appears vulnerable, you must follow it until a judge says otherwise. I know that can be frustrating, but that's how constitutional litigation works. Change takes time. And speaking of time, let's talk about the timeline. These legal battles don't resolve overnight. Some will take months. Others could take years. Appeals will happen. Different circuits may weigh in. Eventually, some of these issues could return to the Supreme Court for further clarification. So we're not waking up tomorrow to a completely rewritten set of gun laws. What we are seeing is a gradual shift in direction. States now face tighter constitutional limits when restricting firearm rights. That's the broader takeaway. And there's another dimension that many people aren't fully considering. This ruling doesn't just apply to state laws. It applies to federal laws too. The same constitutional test, text and historical tradition, applies across the board. Forward. That means federal restrictions are also subject to scrutiny under this framework. Laws involving gun-free school zones, regulations governing specific firearm types, restrictions determining who may lawfully possess a firearm, all of it now falls under the same analytical standard, and that opens the door to challenges at the federal level as well. We may see long-standing federal statutes examined through a new constitutional lens. Some may survive, others may not. What's clear is that the legal environment surrounding firearm regulation has entered a transitional phase. And during transitions, staying informed is critical. Here's what you need to take away practically. First, if you have a concealed carry permit, understand that where you can legally carry may change. Locations that were off limits could become permissible. In some areas that seem legal may be challenged. The landscape is shifting, and staying informed is crucial. Second, if you were denied a gun permit in the past, now could be the time to revisit that denial. The standards have changed. What was a valid reason to deny a permit under old rules might no longer hold under this new Supreme Court framework. Talk to an attorney who specializes in gun rights. They can help determine if you have a viable case. Third, watch your state legislature. Some states will attempt to rewrite laws to fit the historical framework, finding examples from early American history to justify modern restrictions. Other states may ease regulations because they know certain restrictions can't survive in court. Either way, changes are coming, and you need to know what's happening in your state. This unanimous 9-0 decision brought together justices who rarely agree, showing just how clear the constitutional issue is. The Second Amendment has a defined meaning, and states can't ignore it simply because they think a law is good policy. Legal challenges are about to flood the courts. Hundreds of cases across all 50 states. Some will succeed, some will fail, but everyone will use this new text and history test. As those cases are decided, we'll get more clarity on what's allowed and what isn't. But here's the reality. You can't just ignore current laws because you think they might be unconstitutional. Until a court strikes them down, they're enforceable. Violating them can still lead to arrest or charges. Changes take time, months, or even years, but the direction is clear. States now have less power to restrict gun rights than they did before. This ruling could also affect federal gun laws. The same historical test applies to federal restrictions like gun-free school zones, weapon regulations, and who may own guns. Some long-standing federal laws could be challenged in the coming months. So here's the bottom line. The Supreme Court just issued a unanimous decision reshaping gun laws across America. Every state must now justify firearm restrictions using historical tradition, not just public safety. Laws that seem solid are now vulnerable. Legal challenges are coming, and rules you've followed for years may change. Stay informed, monitor your state, consult an attorney for your specific situation. The law is evolving, and you must evolve with it. Finally, if this video helped you understand what's happening with gun rights in America, subscribe to this channel. I break down complex legal changes into simple English, so you're never caught off guard. I spend hours reading court opinions and legal filings, so you don't have to, giving you the straight facts you need to protect yourself and your rights. Hit that subscribe button, and I'll see you in the next video, where we dive even deeper into what this ruling means for your state and your Second Amendment rights.